Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the CreditOrPressShop.com. And in this video, I want to quickly talk about what Portfolio Recovery Associates had to agree to in the 2015 lawsuit with the CFPB, and that how this can help you if you're dealing with them as a debt collection company trying to sue you in court, or any other debt collection company that might be trying to sue you in court. Um, it's This is one of the things that I've always talked about, and I've gave a lot of weight to when it came to dealing with debt collectors. And I don't think that it's nothing new that I'm telling people. I'm not the only one that has ever said that a debt collector must prove, that you owe them. What I believe is unique about what I teach people and what I share with people and how we've helped people win debt collection lawsuits is that we base everything on the debt collector having to prove the claimed amount. Now, what we have right here, this is from the lawsuit in 2015. And after this video, I encourage you to watch the video that I made the other day that shows the now recent lawsuit with Portfolio Recovery Associates brought by the CFPB, the Consumer Financial Protection Bureau. And what they stated, among many things that was stated, was that that Portfolio Recovery Associates did not follow the stipulations that was put in place for them to follow from the 2015 lawsuit. And so they've fined them a total of $24 million. $12 million will go immediately to individuals that were harmed, and then another $12 million will be put into a reserve account for future, because they believe that it happened in 2015. They were warned and they continue to do it. And the reason why, in my opinion, they continue to do it is because they made $181 million in net profits in 1 year. And if you're only going to have at risk of paying out $24 million and you made $181 million, debt collectors are going to make that trade off every day. They're not going to care. If they're going to be able to continue doing business and only pay these fines, which are hefty fines, but you could see that they would make that exchange every day. So I wanted to make you more aware of the actual stipulation, or the actual information that the CFPB revealed in 2015, and something that I've been revealing for years, but I want to use the lawsuit to kind of validate what I've been telling you here on this channel, and what I've been helping my clients with the credit repair shop do when they deal with debt collectors like Portfolio Recovery Associates that are trying to sue them in court. Now, right here on line 28, and I invite you to go and do this research yourself. You go to the CFPB website and you can type in Portfolio Recovery Associates 2015 lawsuit or 2015 stipulations. So you can see right here, I'm going to highlight this section. So right here, this is what we're going to be talking about in this video. So it says here, PRA, Portfolio Recovery Associates, is aware that significant inaccuracies may exist in the sale files it purchases, including that some debt balances were not reduced by a consumer's subsequent payment. So what they're saying here is that payments that were made by the consumer to the original creditor, maybe because the account was going bad for whatever reason. It could be disputed information. You just never know. But the whole bottom line on this is that they were getting information and they knew that it could have errors in it. And they didn't want to do anything about it. They didn't try to do anything about it. And I'm going to get into the reason why. And as a matter of fact, the testimony is going to validate why they don't do it. So it says here again, I'm going to read it. Portfolio recovery is aware that significant inaccuracies may exist in the sale files it purchases, including that some debts balances were not reduced by the consumer's subsequent payments. Now, one of the things that you'll see in these debt collection lawsuits is that they'll have an affidavit that is submitted from the original creditor when they buy the debt. And it's basically just an affidavit that's saying, hey, we sold it to this company, they're responsible for it. But there was something that I had always stated that was missing, and it is also implied by the original creditor that they do not warranty that all of the information is accurate, that the debt collector assumes all the responsibility if anything was inaccurate, anything was missed. Debt collectors know that it is their responsibility to, if asked to validate a debt, it is their responsibility, according to the Fair Debt Collection Practices Act, that they have to verify all of the information and validate that debt. But people don't really know how to make them do it. What they'll usually do is they'll send a couple of statements back, they'll send the affidavit that they bought the debt. Like, they try to keep it all away from what we're talking about right here. So moving forward, for instance, when a portfolio recovery associate senior manager raised a concern about the poor quality of sellers' balance information and asked how portfolio recovery associates can know actual balances owed if it does not receive information on post charge off payments. The portfolio recoveries vice president for collections responded, we don't. 90% of our cases are default judgments. I'll repeat, we don't. This is testimony. Portfolio recovery associates vice president for collections responded, we don't. 90% of our cases are default judgments. We show the judge the math, and if no one disputes, we get our judgment. We show the judge the math, and if no one disputes, we get our judgment. We show the judge the math, which is they don't show them how it adds up, they show them numbers. This should be changed. We show the judge the overall number, and if no one disputes, we get our judgment. Debtors have the right to defend and prove us wrong. I repeat, debtors has the right to defend and prove us wrong. If they show payments we've missed, we amend the complaint. But more than that, they didn't even want to go into more detail right here because it's more than this. Listen to this here. So they're talking about missed payments and balances. They're totally glossing over proving, but this vice president for portfolio recovery says we show the judge the math, and if no one disputes, we get our judgment. What math are you showing? They never show the math of how it added up to be the amount that they're claiming. So this actually is a roundabout false statement. If they were pressed on this, they would basically say, we show the judge a couple of statements, we show the judge the amount that we're claiming, and if no one disputes how we got to that number, that's what this needs to be. If no one disputes how we got to that number, then they get their judgment. If no one disputes how we got to that number, then we get our judgment. Debtors has the right to defend and prove us wrong. How can you, let's just look at it from their point of view. How can you prove someone wrong if they only provide you a couple of statements and they say that you owe this amount of money? How can you prove them wrong? Well, you can prove them wrong by making them prove how they came up with that number. And that's what you have a right to do. So if you're being sued by a debt collector, at minimum, you need to make them prove their claim. Their claim is how they came up with the number that they're claiming that you owe. So if they say you owe $10,000, you want them to prove all of the charges, all of the balances, all of the credits, all of the rewards, all of the signatures that you when you went to the store, whatever you did, your signatures, your PIN codes, everything, advances, everything. You want to look at a full accounting so you can see if they can prove that you owe the amount that is claimed. Don't just leave it as what you see right here. I believe that this is why so many uh, people who are trying to fight for the rights of for people against debt collectors, they just don't break this down and understand. Like, they're looking at what they bring and not looking at what they did not prove. And proof is not just solely based on a contract. Proof is not just solely based on them bringing a few statements. Proof is not solely based on them showing how they purchased a debt. Proof is not solely based on them stating that they're familiar with the way that the books are maintained with the original creditor, which they do not know how the books are maintained with the original creditor. The only thing that they know is how the books are transmitted over to them from the charge-off balances that they purchased. All right. If you need help with debt collection lawsuits, there's a link below this video. We always ask that you go to our website also and upload your court summons into the live chat. We will follow back up with you and let you know how we can help you. So go to the creditrepairshop.com and there's a live chat feature. You can put the upload the information there, and also put a little bit about the background about your specific situation. That can help us when we give that call back. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you see my 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com. Grab your TransUnion, Equifax, Experian credit reports. And again, if you have debt collectors coming after you early in the game before they try to sue you, you have a right to challenge them at the get-go. And I'm going to give you 3 letters to do that. And Portfolio Recovery Associates was actually had a stipulation in the 2015 lawsuit that they had to stop going after individuals that had debt that was past the statute of limitations. They had to notify people that their debt was past the legal statute of limitations to collect. So I'm going to give you a letter. The first one is cease and desist collection act. Well, the first one is statute of limitations letter to stop debt collectors who are trying to collect debt on you, to put them on notice that they're trying to collect the debt that you legally do not have to pay. And then the next one is and you don't have to do a debt validation with that. I give you the instructions on it. The other one is a cease and desist collection activities letter, not to be confused with cease and desist communications. We want to keep the communications open so we can resolve this, but this is where you're going to get detailed about what we just talked about. You're going to make them have to prove every aspect about how they're coming up with their claim, and also to see, among other questions, to make them answer to. You're going to get a full list of those so you can make the debt collector know that you're not, just playing around and trying to run from them. And then I'm also going to give you a debt validation letter so you can go back and forth with them, just in case they try to say, hey, you do have to pay. I'm going to give you a letter that you can utilize to respond to them. Thank you for your time. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.